That's probably why they took it down. Amended trespass claims, the same thing per two different documents. He kept saying torturous interference. He said we were trespassed for torturous interference. But torturous interference is nowhere on any paperwork. What else we got here? I mentioned that the two trespass forms are different from each other. DPPA doesn't mention public photography. Any person knowingly obtains or discloses info from the motor vehicle record. I don't have access to any vehicle record, and those are not my intentions. My intentions are to keep the Bill of Rights intact. And simply that day to make a 30-second record. The Privacy Act also must specifically list what info was retrieved by the offender from the system of records in which it was contained. It also says, I'm sorry?
What are you reading from?
I think that's Lambert versus United States. Okay? Florida Statute 934.02, recording people in a public place is legal as no one has the reasonable expectation of privacy in public, which is what they said in Sheets. In Sheets versus Punta Gorda, the judge said he has the right to record in City Hall, but they're trying to claim that people within City Hall walking around and the employees have a right to privacy, which is nonsense. It's the plain view doctrine. Anything your eyes can see, you can record. Openly, let's see here. So, Katz versus United States, openly recording in public gives notice to public officials and others that they are being recorded. So it's not surreptitious, which is another thing that was brought up in Sheets versus Punta Gorda, that he was engaged in surreptitious recording by wearing a body cam. Or in Katz versus United States, it says everyone's noticed if you're openly recording. So he's not. It would have to be surreptitious and sneaky and shady. And the gravity of the situation, you go back to that. Pasco, and again, when you mention Sheets versus Punta Gorda, I'm pretty sure that's a constitutional trial, but Pasco doesn't have the same ordinance as Punta Gorda, and nor should they, because this would cause a huge uproar, just like it did in Punta Gorda. Smith versus Cummings, the First Amendment protects the right to gather info about what public officials do on public property, and specifically a right to record matters of public interest. How they operate their DMV is a matter of public interest. Time, place, and manner must be evenly applied. So if I'm trespassing recording, but Dan wasn't trespassed the 2 times he came in, and you saw Mr. Jerry here say that I don't have a problem with you recording. Requiring permission to engage in the First Amendment is not free press. It's called prior restraint. It would be the same thing as saying you must cover your ears when you're here because you might hear something that the DPPA covers. Smith versus Cummings is also backed by Blackston versus Alabama, Iacobucci versus Bolter, United States versus Hastings, Nixon versus Warner Communications, Lambert versus Polk County, Thompson versus City of Clio, Kelly versus Page. DMV may not use police in order to thwart or intrude on First Amendment rights other than being validly asserted. Heckler's veto. That's when the hecklers started coming at me because the DMV claimed they were forced to stop serving the public because we were standing there peacefully trying to get a 30-second transaction on the record. I was also threatened by the public after they took those actions. The only disruption that occurred was after they took their actions that they made out of whole cloth from their department policy. That should tell you right there it's a bad policy. He didn't bother to come up and say, what are you doing? Nobody told me I was blocking anybody. Nobody told me I was disrupting anybody. The only time anything happened was after they decided to stop serving the public and blame us for it. This is a common tactic they use. We've seen it before. What else we got here? I'm really thirsty, so that's it for me, man. Thank you for being so lenient, and thanks for your time. I really appreciate everything you've done for me today.
We'll hang that very briefly. I'll just from council's table. 66-159. It hasn't been amended in years. There wasn't an amendment after this happened or anything. And section 2A2 has always read on
And the
that.
signs must pass a legislative body. It can't be made a department policy out of whole cloth. Otherwise, they could reverse any decision any court's ever made, just sit around a table and draw up a sign. That's the problem there.
I would say too, Mr. Fasano is an elected official. He's able to set policy within his office. His management is able to set policy within their office. There's no tax collector or legislative body that has to pass. They can set policies.
It must be constitutional. It must be a lawful sign. You can't just write anything you want. Yes.
Mr. Filax argued in his closing argument some of the factors that the authorized person should consider, and he really harped on the gravity of the alleged violation. I want to point out there's 2 other factors in there that he didn't mention. Any previous violations committed by the respondent, which was testimony that Mr. Filax had showed up at their property and video recorded previously, as well as the harm or potential harm to the public or property threatened by the respondent's actions. I think potential harm is very important.
I did mention that.
Right, you had your chance to present our.
Okay. I'm not sure how this works, so I apologize.
That's very clear. So it's the potential harm that is initiated by misconduct, and that's a factor that can be considered. The case law he cited, so he didn't do the professional courtesy of providing a copy in advance, but it all has to do with traditional public forums. Smith v. Cummings is the police out on the street. It's a traditional public forum. CAC was out on the street. Brandsburg had to do with journalist rights not to testify in grand jury proceedings. But he hasn't touched on anything involving a limited public forum, which is what the Sheets case was, which the tax collector's office was. And it's not the same constitutional scrutiny. It's not strict scrutiny. It's a very different standard. Is the policy reasonable, and is the policy content neutral? And again, I got to emphasize this body has no jurisdiction to consider even the constitutionality of the policy, but since it's been discussed so much today, it clearly passes that test. And again, Mr. Filax has indicated he didn't read it, so how he can conduct that analysis, I don't know. He's also made an argument about the law enforcement officer do not forward the trespass warning to the county attorney's office within 24 hours. However, he said he believes so. There's no testimony on the record whatsoever. He could have asked Deputy Penny that. He didn't. There's nothing on the record.
Object to that. I said I would play you the video clip of him specifically saying he hadn't received it.
It's not evidence in the records.
I wasn't allowed to put it in the record then. I have all the video you need. I'll gladly put it into the record. He specifically said he didn't receive it.
So I think pretty clear on the record, Mr. Filax has had opportunity to be heard. He's had opportunity to cross-examine every witness. He's had opportunity to testify, to present witnesses, to present closing argument, and then includes introducing evidence. The fact that he failed to do so, and now after the fact wants to argue, well, I could have introduced the evidence, or I have it, but I didn't introduce it. That's on him.
I was told you didn't need it.
That was a closing argument. It was too late to introduce evidence.
Did you say you didn't receive it on the 15th?
So the only other point I want to make is that he made an argument about, how did they get my driver's license information? There's foreign law enforcement. They're allowed to look that up. It's very different than a member of the public. That's
I can redress that?
Sure.
They claim they got it from my driver's license. I didn't hand it to anybody. Any policies made have to be constitutional. Regardless, from top to bottom, bottom to top, they have to be constitutional. It has to go through some body, and even though Mike Fasano's elected, any policy he makes still has to pass constitutional scrutiny. We were not in any offices. We were in a public place where the public has access, and anywhere the public has access, the free press also has access. Otherwise, you're discriminating. And by asking for permission is prior restraint against something that would be like telling everyone to close their ears when they go in there because you could hear some sensitive information. Thank you, sir.
I'll provide a written ruling within 7 days, but I will find that I don't have any ability to determine the constitutionality of the policy of tax collector's office. The whole purpose of this appeal is to determine if the trespass warrant was properly issued pursuant to the county's code. Those issues are what's at hand. So the challenge of constitutionality of the policy is something that would have to be done through the court system.
I hear you, but that's not the only challenge I made. There's a lot more than that.
I just wanted that was
Okay.
part of this.
Okay.
I don't have the ability or the manner to rule on those, so.
I understand, just as part of the totality of the circumstances.
I understand that. So I'll make a written ruling as case law review, and I'll take into account all the evidence, and we'll send it to you. Is it sent through the U.S. mail? Or email, or?
We have email and we'll send it over.
And may I send you the video where he says on the 15th he still hadn't received it, even though.
I can't consider that.
Okay. Even though it's public info, it's out in the public, anyone can look it up.
I can't consider it because it wasn't put in the evidence.
Can I amend the evidence? I mean, we're talking about a flub that with all this documentation, didn't submit that video to you because of a procedural issue. It's very important that it has to be there within one business day, and he's using the fact that it's not in evidence as if it didn't happen. It did happen, it's in public, I have it on video, I can show it to you right now. He did not have it on the 15th, he did not have it.
Do you have a response to this?
Yeah, I mean, I would stipulate, you don't need to see it. He came into our office to serve the appeal on the 15th and asked if we had received the copy from the sheriff's office yet. I said, to my knowledge, I didn't have it. What the ordinance says is that the deputy must forward it within 24 hours. So I have no idea when they sent it. And that's really kind of the important analysis on that issue.
But he didn't have it 5, 6, 7 business days later. He didn't have
I
it.
didn't know if my office had it when he came in on the 15th. I don't think it really speaks to when they forwarded it.
When did they forward it?
Would be a question for deputy.
Okay.
I agree with it, I'm sorry, but my office gets things all the time that I don't really get that are there.
I'll gladly email you anything you'd like to see. Yeah, he did say he checked his emails. He said, to my knowledge, it's not here. No one here got it. And he specifically said that he did not get it on the 15th.
Thank you.
So we just wait for your verdict through the mail, basically?
Yes.
Your Honor, thanks for being so patient. I'm sure it was tough. I appreciate you, man. Have a good day. Well, a lot of judges don't do it the way you did it. Now I'm really thanking you for that. So we're done in here, right?
We're done.
Have a good day, sir. Thank you. You too.
Seeing you, man.
It's under their policy, wouldn't go right out the door if everyone did what I just did.
Yep.
Yeah, I did forget a few things, but I thought I was pretty damn thorough.
You were for, better than I could. I can elevate it over there and get there.
Let's go, you bitch.
Yeah, you've done way better than I could have done, John.
Thanks, man. That'll make some good content anyway.